People like you don't come through this entrance. The public waiting area is that way." Those words were still hanging in the air of the Harmon County Courthouse hallway when everything that followed became inevitable. But we will get there, because to understand what those words cost, the man who said them, you first need to understand the man they were said to, and why he was standing in that hallway at 7:38 on a Tuesday morning in October, when most people in that building were still pouring their first cup of coffee. Elijah Cross was 44 years old, lean in the way that comes from 15 years of running before dawn and not sleeping enough and carrying things internally that other people would have set down a long time ago and never picked back up. He had driven to the courthouse in the rain, and his navy jacket was still faintly damp at the collar, and the toes of his dark shoes were wet from the puddles on Congress Avenue, and he had not stopped to fix any of it because he was not thinking about how he looked. He was thinking about the cross-examination question he had written 3 different ways the night before, and still wasn't satisfied with turning each version over in his mind, the way you turn a key in a lock that isn't quite catching. He carried a slim folder under his left arm and a worn trial notebook under his right. The notebook's spine repaired twice with black electrical tape, because he had used the same one for 6 years, and was not going to replace it until it fell apart completely, and it had not fallen apart yet. No briefcase, no associate trailing behind him with a cart of documents, no expensive watch on his wrist to signal that he had arrived. Just Elijah, just the notebook, just the work. He was the special prosecutor appointed by the Florida Attorney General's office to lead the most consequential public corruption trial Harmon County had seen in 15 years. 12 defendants had been indicted. The case had taken 8 weeks of preparation, 2 full-time investigators, and more late nights than he could count without feeling tired just from the counting. The trial was scheduled to begin at 9 o'clock that morning in courtroom 6B, and Elijah had come an hour and 20 minutes early because 15 years of standing in courtrooms had taught him something that no law school class had ever bothered to mention. The hour before a major trial reveals things the trial itself never will. Who clusters near which doors, who whispers and who performs, whose confidence is real and whose is borrowed from the reputation they arrived with. There was one other thing in his jacket pocket, something small and quiet and completely decisive in ways that no one, including Elijah himself, was fully thinking about yet. His phone was running a passive audio capture application that had been uploading to a secure cloud server every 3 minutes since he stepped through the metal detector at the building entrance at 7:36. He had built the habit 4 years earlier after representing a young man named Terrence, who had been charged with resisting arrest, a man who had described in precise and unflinching detail exactly what the arresting officer had said during the stop, and whose account had disappeared completely into the gap between what was remembered and what was written down. The case was resolved, but Malcolm had walked out of that courthouse carrying a specific and quiet fury at how easily the truth could be erased when no one outside the moment was listening. The application had been running ever since. He was not thinking about it. He was thinking about the cross-examination. Brett Calloway had been working courthouse security at Harmon County for 13 years, and in those 13 years he had developed what he privately and sincerely believed was a finely tuned ability to read a situation in the time it took most people to read a name badge. He was 51 years old, with close-cropped silver-blonde hair the color of old wheat, a jaw that looked like it had been squared off with a carpenter's tool, and small, pale blue eyes that his ex-wife had once described not affectionately as eyes that were always checking something, even when there was nothing left to check. He had wanted to be a police officer. He had tried twice, failed the physical exam at 28, tried again at 31 and missed the threshold by a margin that was smaller than the first failure, which somehow made the second one considerably harder to carry. The courthouse security position had come open a few months after that, and he had taken it with an understanding that was never spoken aloud between him and anyone else, but was present in every room he ever walked into, wearing the uniform, This was the closest approximation of what he had actually wanted, and authority in whatever form it arrived was something he was going to wear completely and without apology. In 13 years, he had received 14 documented complaints. His supervisor, Dennis Howell, had told him after the fourth one that deputies got complaints, that was the nature of the job, and Calloway had carried that reassurance forward like a credential of his own. He had never been formally disciplined. In his mind, this confirmed everything about how those complaints should be understood. 11 of those 14 complaints had come from Black or Latino attorneys, witnesses, or court-appointed advocates. 3 had involved Black attorneys there to represent clients in active cases, and 2 of those 3 had filed formal complaints that had been reviewed closed without finding and filed into a drawer that no one ever opened again. Calloway had never seen the data assembled in one place. No one had assembled it. No one had shown it to anyone. This morning, he was posted at the special access corridor leading to courtroom 6B, the largest and most visible assignment in the building, because the trial starting today was the kind of trial that put a courthouse on the news, and Calloway had volunteered for the post 3 days in advance. He stood with his feet planted and his shoulders back and his pale eyes already working the corridor the way he always worked, a corridor, checking, assessing, cataloging, deciding. Raymond Okafor had been awake since 4:30 in the morning, which was not unusual for him lately, because sleep had become something that happened to other people who were not scheduled to testify in a federal corruption trial in approximately 4.5 hours. He was 56 years old, and he had worked for Harmon County Public Works for 21 years. And for 21 years he had done his job with the methodical and unglamorous commitment of someone who understood that roads needed to be maintained whether anyone was watching or not. He had pressed his dark charcoal suit himself the night before, the one he had bought for his daughter's college graduation 5 years ago, and he had done it carefully. The way you do something when you understand that how you present yourself in a particular moment is a form of statement about how seriously you take the moment. He was sitting in the 4th row on the left side of courtroom 6B in the spot he had chosen because it gave him a clear line of sight to both the door and the witness stand, and because sitting near the aisle made it psychologically easier to remind himself he was choosing to stay rather than being trapped there. The courtroom doors were still open at 7:40. And from where he sat, he could see the full length of the special access corridor, where a security deputy with silver blonde hair was standing with the settled posture of a man who has already made most of the decisions he intends to make today. Raymond had thought about not coming 3 times in the last 2 weeks. 3 times he had made himself get up and go anyway because the alternative, going home and living with what he knew, carrying it forward into another year and then another, watching the people who had done it continue to do it in new configurations, was something he had finally decided he could no longer do. He had reached out to Elijah Cross's investigative team 9 months ago through a public integrity hotline, which had required a kind of courage that he had not told his wife about, because naming it would have made the fear more real. He was watching the corridor. He was watching the deputy. And somewhere in the back of his mind a thought was forming that he had not quite let himself finish yet. If they can do that to the prosecutor right here on the first morning. Elijah was still working through the 3rd version of his cross-examination question when he became aware of the deputy's posture, not through any deliberate observation, but through the particular instinct that develops in anyone who has spent 15 years walking into rooms where someone has already decided they shouldn't be there. He recognized it the way you recognize weather changing, not by thinking about it, but by feeling the air differently before you can name why. The slight forward lean. The feet planted. The eyes doing their work without any attempt to conceal the work they were doing. Calloway ran his visual sweep in under 3 seconds the way he had been running sweeps for 13 years. Navy jacket imperfectly dried, still dark at the collar from the rain. Shoes wet and dark at the toes. Slim folder, no weight to it. Notebook with electrical tape on the spine, clearly old, clearly used, not the kind of notebook a person carries to look important. No tie, no briefcase, no associate, no expensive watch. Nothing about the appearance of a man who belonged in the special access corridor at 7:40 in the morning on the first day of the most high-profile trial this courthouse had hosted in 15 years. The assessment was complete before Elijah reached conversational distance. Calloway positioned himself slightly forward of the access point, feet still planted, pale eyes fixed, and decided, and waited. Elijah did not slow down. He did not speed up. He stopped at a natural and courteous distance and looked at the deputy with the expression of a man who has been through this before and intends to be reasonable about it while remaining completely clear. Calloway did not say good morning. He said, "This corridor is restricted access. You need to head back to the public waiting area," and the words came out in the flat and final tone of a man delivering information rather than making a request. A man who considers the matter already settled and is only waiting for the other party to catch up. Elijah told him calmly and clearly that he was the special prosecutor appointed by the state attorney general's office and needed to access courtroom 6B. He said it in the way he said most things in professional settings, without performance, without hedging, without any invitation for negotiation on the underlying fact. Calloway looked at him and asked which defendant he was related to. Those specific words. Which defendant he was related to. Elijah absorbed that the way he had learned over many years to absorb that particular category of assumption, not by pretending it hadn't landed, not by letting it show that it had, but by feeling it fully and precisely for exactly one moment, and then setting it down the way you set down something very hot before picking up what you actually came for. He told the deputy he was not related to any defendant. He was the special prosecutor for the state. He produced his bar card, which was in a temporary plastic sleeve because his wallet had been damaged in a rainstorm 2 weeks earlier, and his letter of appointment bearing the seal of the Florida Attorney General's office, the case number, and his full name in the heading. Calloway looked at this bar card. He looked at the appointment letter. He read the heading and stopped. He did not read further. He said he had seen fake paperwork before and that the plastic sleeve looked wrong. His voice had the particular flat certainty of a man who considers himself very good at recognizing things. Elijah kept his voice measured and offered 3 independent verification methods, the way a man offers options when he knows the truth and wants to give the other person every possible chance to find it too. Check the court docket, which would list his name as lead prosecutor for case number 2024-CR-0891. Call the clerk's office at extension 118 and ask for Sandra O.C., or contact Judge Wynn's chambers directly. He said he would wait as long as any of those 3 checks required and that he understood the deputy had a job to do. Calloway said he was not going to hold up a courthouse on the basis of a piece of paper in a plastic sleeve, and his voice when he said it had the slightly louder quality of a man who wants the corridor to hear him being decisive. 2 reporters standing near the far end of the corridor had drifted closer the way people move toward tension without quite making the decision to move, and at least one phone had been raised, and Elijah was aware of all of it, and kept his eyes on Calloway, and kept his voice low because he had one objective, and it was not creating a scene. It was getting through that door and doing the job that 12 defendants and a county full of defrauded taxpayers were depending on him to do. Calloway reached out and gripped Elijah's arm. Elijah said precisely and quietly, his voice not rising by a single degree, that he was asking the deputy not to touch counsel. And Calloway said it. The sentence that the recording device in Elijah's jacket pocket captured with complete clarity and uploaded to a secure server in the cloud at 7:51 and 3 seconds in the morning. Counsel doesn't show up looking like he came from a bus station. Then Calloway walked him to the public waiting area, told a second deputy not to allow him back through without real credentials, and made air quotes with his fingers around the word real. The phone in Elijah's jacket pocket kept recording. The public waiting area of Harmon County Courthouse was a room with long wooden benches and overhead lights that hummed at a frequency just slightly below the threshold of conscious annoyance, and it was filled at 7:53 in the morning with the particular mixture of people that public waiting areas at courthouses always hold family members of defendants. In minor cases, witnesses who had been told to arrive early, A few people who had confused the courthouse with the county clerk's office 2 blocks north. Elijah stood rather than sat. He held the notebook under his arm and looked at the heavy wooden doors of courtroom 6B from across the lobby and thought about Raymond Okafor sitting in the 4th row on the left side of that room, and what it must look like from the 4th row to see the prosecution table sitting empty. He made 1 phone call, 3 sentences. He gave Darius Webb, the Attorney General's representative, who was 11 minutes away in traffic, the deputy's full name, the badge number he had read from the left breast of the uniform, and a factual summary of what had occurred. He did not editorialize. He did not describe how it felt. He hung up. Then he stood in the public waiting area with the people who had come to watch and thought about the cross-examination question he still hadn't resolved, and on the 4th revision standing in that room with his damp jacket and his worn notebook, the phrasing finally came to him, and he wrote it down with the pen he kept clipped to the back cover. Because the work was the thing. The work was always the thing. Whatever was happening around the work, the room it was happening in, the people who had decided what category he belonged to before he opened his mouth. None of that changed what the work required. He had 13 minutes before the trial was scheduled to begin, and he used them. He stood in the waiting area of the courthouse that had just told him he didn't belong there, and he prepared, and the phone in his jacket pocket uploaded another increment of audio to the cloud at 7:54, and again at 7:57, and again at 8 o'clock. Dana Park had been a reporter at the Harmon County Gazette for 11 years, and she had been in the courthouse since 7 o'clock that morning, because 11 years of covering courts had taught her that the hour before a big trial was worth more than the first 2 days of testimony combined. She had watched the entire exchange in the access corridor from 30 feet away, and she was already composing a text to her editor that read, "Something happened this morning. Need to talk before I file anything. Stay near your phone." Craig Simmons was a freelance videographer who had been hired to shoot general courthouse atmosphere footage for a documentary project that had nothing to do with this trial. He had been filming at a wide angle and did not know yet with any precision what he had, but he knew the feeling of having captured something significant, the way you feel the weight of a moment before you can name what it weighed. Inside courtroom 6B, the defense team for the lead defendant, Gerald Harmon, was arranging itself with the choreographed calm of people who are very practiced at projecting calm regardless of what they actually feel. Harlan Burke, who had spent 23 years defending clients in federal and state courts, and who billed at a rate that required his clients to be wealthy or desperate, or both, emerged from a side doorway and observed what remained of the corridor exchange with pleasant and careful curiosity. He asked a second deputy standing near him whether security was in the process of removing someone, and his voice, when he asked it, had the specific quality of a man who is filing information away rather than expressing surprise. In the 4th row on the left, Raymond Okafor had seen all of it through the open courtroom doors. He watched Elijah Cross walk toward the waiting area. He felt something cold move through him, slow and specific, settling into his chest, in a way that made the already difficult task of sitting still in this room suddenly considerably more difficult. Dennis Howell had the particular coloring of a man who had spent decades in administrative positions, just close enough to real power to be protective of it, without quite possessing it himself. Thinning blonde hair, gone pale at the temples, a face that went red quickly under stress. The permanent expression of someone managing a situation he considers beneath his actual status. He was reviewing the morning's access logs at 9:34 when the first call came from a reporter at the Gazette asking whether a deputy under his command had removed the state's lead prosecutor from the courthouse building earlier that morning. Howell issued a statement in the time it takes most people to make a pot of coffee. He did not review the surveillance footage first. He did not examine the full access log. He did not ask Calloway for a detailed account of what had specifically been said. He said that Deputy Calloway had enforced the standard credential verification protocol as required by courthouse policy. He said that any individual who could not verify credentials on site was subject to removal until verification could be established through proper channels. He said the deputy had acted appropriately and professionally, and that the courthouse stood behind that assessment. The statement appeared in 3 different news stories within 40 minutes, and by 10:15 in the morning, the institutional frame was built and circulating. This was a protocol dispute, a credential problem, a miscommunication between a security deputy following procedure and an attorney who hadn't presented his paperwork in the right form. 2 of the 4 initial stories quoted the courthouse's defense of Calloway before they quoted Elijah's account. The phrase "standard verification protocol" appeared in the headline or the first paragraph of 2 stories. Not one of the initial reports mentioned that Calloway had physically gripped Elijah's arm. Not one mentioned what had been said about a bus station. Not one mentioned that 3 independent verification methods had been offered and refused. The frame was doing its work, and the frame was entirely wrong, and it was spreading. The way wrong things spread when institutions are fast and witnesses are not yet organized. Raymond Okafor had gone back to the 4th row on the left after the courtroom doors closed, and he was sitting very still in the way that a person sits still when they are working very hard to keep something from showing on their face. He had 21 years of watching things happen in Harmon County that should not have been allowed to happen, and he had spent the last 9 months building himself up to the specific act of coming to this building and sitting in that witness chair and saying out loud in a room with a judge and a jury and lawyers and a permanent record exactly what he had seen. 3 separate times in the 2 weeks before the trial he had thought seriously about not coming. 3 times he had gotten up in the morning and made himself get in the car anyway, because the alternative, carrying this knowledge forward into another year, watching the people who had done it continue operating with the easy confidence of people who know. They will not be called to account was a weight he had decided he could no longer hold. But now he had watched the special prosecutor for the state of Florida be walked to the public waiting area by a security deputy who had looked at him and decided in 3 seconds what category he belonged to. And the thought he had been pushing back for the last 20 minutes was finishing itself, despite his best efforts. If they can do that to him right here on the very first morning in front of reporters with cameras on the wall, what exactly are they planning to do to me when I climb into that witness chair? He sat very still. He did not leave his seat, but something in him was doing a calculation he had not asked it to do. Carol Tran was still in her car in the parking structure at 8:15 in the morning when the news of what had happened in the access corridor reached her through 2 different text messages from 2 different people who had been in the building. She read both messages and then put her phone face down on the passenger seat and looked at her own hands on the steering wheel for a moment before she looked up into the rearview mirror at her own face. She was 49 years old and had worked as a senior clerk for Harmon County's procurement office for 16 years and for 18 months. She had been living with the knowledge of 31 specific invoices she had printed, folded into a manila envelope, and locked in a fireproof box under the bed in her spare bedroom. She had put them there because she had been instructed to delete the originals from the county's document management system, and she had deleted them from the system, but she had not been able to make herself destroy the only evidence that they had ever existed, even though she had understood from the moment she printed them that keeping them was a form of danger. She had not come forward sooner for a reason she had never said out loud to anyone, including herself, in exactly these words every time she imagined calling someone official. She imagined being the person in the room who speaks clearly and is not believed. She picked up her phone. She put it back down. Then she opened the car door. Patricia Owens found Elijah in the corridor outside courtroom 6B during the mid-morning recess on the first day, and the way she approached him quietly from the side with the particular care of someone carrying information they are not sure they should be delivering told him, before she opened her mouth, that this was not a routine message. She told him that a witness had approached her during the break, a Black County employee who was on the schedule to testify. He had watched Elijah be removed from the building that morning and then watched him return and take his seat at the prosecution table, and he had told Patricia that the watching had almost made him leave, not step outside for air, not take a few minutes to collect himself. Leave. Disappear. Not testify at all. He had said to her almost word for word, "If they can do that to the prosecutor on the first morning right here in this building in front of everyone, then what are they planning to do to me when I actually get on that stand?" Elijah stood in the corridor with that information and understood precisely what it meant. A man who was prepared to tell the truth had been threatened not by the defendants, not by their attorneys, not by any of the forces that the trial had been built to confront, but by a security deputy at a door who had assessed a man's appearance and made a decision. He asked Patricia to tell the witness without using his name that the prosecution table would be occupied, that he was not going anywhere. Judge Patricia Wynn had been on the bench for 18 years, and in those 18 years she had built a reputation in the Harmon County legal community that rested on three things: an absolute intolerance for time wasted in her courtroom, a near photographic familiarity with the federal rules of evidence, and an ability to detect the precise moment when someone in her courtroom was performing rather than participating, that her law clerks privately described as almost supernatural, and her colleagues more precisely described as the inevitable result of watching 10,000 people try to be convincing under pressure. She took the bench at exactly 9 a.m., adjusted the microphone, opened the day's docket, and looked at the prosecution table. It was empty. The courtroom absorbed this fact in stages, a murmur from the gallery. Then a charged and particular stillness, the kind that settles over a room when something has gone wrong and everyone knows it, and no one knows yet how wrong. The clerk tried to reach the prosecution team by phone. The call rang 4 times and went to voicemail. Harlan Burke rose to suggest, with the pleasant and carefully calibrated concern of a man who had been waiting for exactly this kind of opening, that the state's apparent absence on the morning of such a consequential trial raised serious questions about the prosecution's overall level of preparation. Judge Wynn looked at him. The look lasted approximately 1.5 seconds. Burke sat back down. She told the clerk to try again. Calloway was posted near the courtroom wall covering the gallery, the way he always covered it when Judge Wynn was on the bench, watching for disruptions and maintaining the kind of visible presence that the assignment required when her voice came clearly across the room, clear and specific, and carrying the weight of a question that had stopped being a simple procedural matter and become something else entirely. "Where is Mr. Elijah Cross?" The name connected with the events of the morning with a force that was entirely physical, not metaphorical. The kind of force that manifests as a very specific sensation in the body before the mind has finished processing what just happened. Calloway's right hand, which had been resting flat against the wall to his right, slid downward approximately 8 inches before he caught himself and stopped it. He looked at the floor. In the press row, Dana Park was looking directly at him at exactly that moment. She wrote something in her notebook, pressing down harder than usual. Calloway reconstructed the morning rapidly and involuntarily, the way you replay a sequence of events that has just produced a consequence you did not anticipate. The navy jacket still damp at the collar, the appointment letter with the seal of the State Attorney General's office, the heading he had read, and the rest he had not read. The 3 verification methods listed with the ease and specificity of someone who had given the same information before in the same calm voice, not because they were bluffing, but because they knew exactly what was true. Darius Webb came through the parking structure entrance at 9:16 and saw Elijah's face and asked no questions. That was one of the things Elijah had always appreciated about Darius. He read situations accurately and efficiently and did not require the situation to be explained to him before he responded to it. They walked in together. Elijah had not changed a single thing about his appearance. The same navy jacket still carrying the faint dampness at the collar from the morning rain. The same shoes still dark at the toes. The same folder, the same notebook with the black electrical tape on the spine. The absolute and deliberate refusal to apologize through his clothing, through his posture, through the speed of his walk for the assumption that had been made about him. 3 reporters in the lobby looked up simultaneously as he came through the entrance. All 3 within the space of 2 or 3 seconds shifted their gaze to the courtroom wall where Calloway was standing. Elijah did not look at Calloway. He walked to the side door of courtroom 6B. He put his hand on the door. He pushed it open and walked in. The side door of courtroom 6B opened at 9:19 a.m., and Darius Webb entered first, and Elijah Cross came in behind him, and the press row registered both men before anyone said a word. Registered not just their presence, but the specific and deliberate nature of how they arrived. Elijah set his folder on the prosecution table. He pulled out the chair. He sat down, opened the notebook to the page he needed, and looked up at the bench with the unhurried calm of a man who has arrived at the place he is supposed to be and intends to do the work he is here to do. In the fourth row on the left, Raymond Okafor let out a breath that he had been holding without quite realizing. He had been holding it for 17 minutes. In the press row, Dana Park wrote 3 words in her notebook, circled them twice, and put a star next to the circle. Harlan Burke, who had been making a quiet comment to his co-counsel about the state's tardiness, went quiet before he finished the sentence. And Calloway, standing against the courtroom wall in the dress uniform that Dennis Howell had told him to wear today because the courthouse was behind him and protocol was on their side. Calloway watched Elijah Cross sit down at the prosecution table in the same jacket and the same shoes, and with the same notebook open in front of him, and something that had been sitting in him since 9 a.m. when he heard the judge say that name shifted in a way that he could feel but could not have named. Judge Wynn addressed the prosecution table directly by full name and by title, and asked whether the state wished to place anything on the record given the circumstances of the morning. Elijah stood up. He spoke for approximately 45 seconds, which was enough. He said the prosecution was ready to proceed. He said the record should reflect that he had arrived at the Harmon County Courthouse at 7:38 a.m. that morning, that he had been stopped at the special access corridor by a courthouse security deputy, that he had presented valid professional credentials and a state appointment letter bearing the Attorney General's seal, that he had offered 3 independent methods by which those credentials could be verified, and that he had been physically removed from the building by the deputy without any of those methods being used. He said the removal had been recorded on his phone, which had been uploading to a secure server, and that he was prepared to make that recording available to the court. He sat down. The room was quiet in a very specific way. Not the quiet of a room in which nothing is happening, but the quiet of a room in which people are processing information and understanding all at more or less the same moment that the situation has just changed shape. Harlan Burke rose and suggested that the state's situation raised questions about capacity and preparation that warranted at minimum a brief continuance. He said it with the practiced pleasantness of a man who has spent a career turning other people's difficult moments into strategic advantages. Judge Wynn denied the motion. She did not explain the denial. She turned to the courthouse marshal, Theodore Park, who had worked the building for 22 years, and she instructed him in a voice that was entirely level and entirely clear to preserve all surveillance footage from every corridor and access point adjacent to courtroom 6B from 7 a.m., forward to collect the names of every person present in the 6B corridor between 7:30 and 9:20 a.m., and to have a preliminary report in her chambers within 30 minutes. Then her eyes moved to the wall where Calloway was standing. She held the look for exactly 2 seconds. In courtroom 6B on that morning, 2 seconds was enough for everyone in the press row to understand with complete clarity what that look meant. She returned her attention to the bench and called proceedings to order. Elijah delivered his opening statement on the afternoon of the second day, and it ran 29 minutes, and he did not mention Brett Calloway's name once. He did not describe what had happened to him in the access corridor the previous morning. He did not use his own experience as material or as sympathy or as anything other than what it actually was, which was private, which was his. What he did instead was this. He told the jury that the case before them was about how institutions are capable of functioning as protection systems for the people on the inside, while failing not accidentally, not through oversight, but through the repeated and embedded habit of small daily decisions, the people those institutions were originally built to serve. He said corruption of the kind they were going to hear about over the next several days didn't happen in secret rooms in the middle of the night. It happened in ordinary office buildings during ordinary business hours in the language of memos and approvals and the phrase standard procedure. It survived, he said, because people in positions of authority made consistent decisions about whose questions deserved real answers and whose concerns could be safely set aside. He said sometimes it happened in contracts, sometimes it happened in reports, sometimes it happened in the way a door was opened or held shut. He said it simply. He did not stay on it. He moved to the specifics of the case. 3 jurors looked at each other in the moment after that last sentence. Harlan Burke, 23 years of reading courtrooms, understood he was already behind. Raymond Okafor took the stand on the 3rd day of trial, and before he said a single word, he did something that was not dramatic and was not theatrical, but that everyone in the room registered anyway. He sat down in the witness chair and straightened his back and placed his hands flat on his thighs and looked at the courtroom with the careful and deliberate posture of a man who has decided, and not casually, that this is the moment he is going to hold himself to a standard he has been preparing to meet for a very long time. He testified for 2 hours and 50 minutes. He described how his supervisor, a man named Victor Pratt, had on 7 separate occasions instructed him to process approval documents for equipment deliveries that Raymond knew from his own direct field work had never been made, had never arrived, had never been installed, had never existed anywhere outside of the invoices that were being submitted and approved and paid. He described the specific morning 13 months ago when he had raised the concern directly with Pratt and been told in words that were simple and clear and apparently intended to leave no ambiguity that his continued employment would benefit from his continued cooperation. He described going home that night and sitting at his kitchen table for 2 hours and then printing 54 documents, invoices, approval forms, email chains, and driving them to his sister's house in a manila envelope with his own name written on the front. Because if something happened to him, he said there needed to be a trail that someone else could find, and the official record was not a trail he trusted to stay where he put it. He had held those documents for 2 years before calling the Public Integrity Hotline. On cross-examination, Harlan Burke spent nearly 4 hours across 2 sessions attempting to establish that Raymond's motive was personal resentment rather than public duty, surfacing a performance review from 7 years back, implying without quite stating directly that this was a disgruntled employee who had dressed up a grudge in the clothing of civic responsibility. Burke was very good at this. He had been doing it for 23 years, and he understood exactly how to make a jury start wondering. But Raymond answered every question in the sequence it was asked with the steady and unhurried precision of a man who had spent 2 years preparing for this specific conversation and who had documented every step along the way specifically so that his memory would not be the only thing the jury had to rely on. When Burke finally asked whether he had a personal problem with Victor Pratt, Raymond said yes. He said the problem was that Victor Pratt had asked him to commit fraud. He said he had documented every time he raised the concern through official channels, beginning with a written memo to the department head dated 26 months before today. He said he had not expected anyone to listen. He had documented it anyway because the documentation was the version of events that couldn't be quietly rewritten. Burke had no further questions on that particular point. Carol Tran took the stand on the 4th day, and she was soft-spoken in the way that some people are soft-spoken, not from lack of conviction, but from the discipline of someone who has spent a long time choosing words very carefully. She had spent the 3 weeks before her testimony cycling between absolute certainty and paralyzing fear in intervals of roughly 4 hours, and she had come anyway every morning and sat in the chair and prepared. She testified that she had been instructed by her division supervisor to delete a specific set of vendor invoices, 31 of them covering a period of 11 months, from the county's official document management system. She had deleted them from the system. She had not deleted the copies she had already printed and placed in a manila envelope and locked in a fireproof box under the bed in her spare bedroom, where they had stayed for 18 months. She said she had not come forward sooner because she was afraid of exactly one specific thing. She was afraid of being the person in the room who speaks clearly and completely and is not believed. When Elijah asked her during direct examination what had changed, what had finally brought her to this courtroom today, Carol looked at him for a moment before she answered. And it was not a long moment, but it was a genuine one. the look of someone who is about to say something true that they have not said out loud before. She said she had seen the news coverage from the previous week. She had seen a man in a plain jacket get walked out of this courthouse by a security deputy who had decided without asking that he did not belong here. And then she had watched that same man come back through the door, sit down at the prosecution table, open his notebook, and keep working. She said if he could do that, if a person could be told by the building itself that he wasn't wanted here and come back anyway and do the work, then she could do this. The courtroom was completely still, not shocked silent. Deliberately silent, the way people go quiet when they are processing something that is true and real and that they are going to carry with them for a long time after they leave this room. The marshal's report arrived in Judge Wynn's chambers at 10:47 a.m. on the second morning, and Theodore Park had attached a handwritten note to the front page that said simply, "See Credential Challenge, Frequency Entries, 2021 to present." Judge Wynn read the access log for 4 minutes without moving, then told her law clerk Priya Subramanian to cross-reference the 16 flagged entries against the court's attorney registry organizing by race and ethnicity. Priya brought the cross-reference back 38 minutes later. 13 of the 16 credential challenges that Deputy Calloway had initiated over the prior 3 years involved Black or Latino attorneys, witnesses, or court-appointed advocates. 9 of those 13 had been delayed more than 6 minutes. 3 had been turned away without entry. 2 of the 3 had filed formal complaints. Both complaints had been reviewed closed without finding and placed in a file that no one had opened since. During the same 3-year period, no white attorney had been denied entry to the courthouse or removed from the building. Judge Wynn sat with the document for a long moment. Then she instructed Priya to transmit the access log and the cross-reference to the Florida State Law Enforcement Division with a cover letter stating that the court had found probable cause to believe the data reflected a pattern of racially motivated credential discrimination embedded in the courthouse's security practices. She said the original documents were to be preserved in the court record. She said none of this was to be discussed outside her chambers until the contempt hearing she intended to schedule for the 6th morning of trial. What she did not do was notify the courthouse administration in advance. They would find out when everyone else found out. The Florida Bar Association received the first of what would eventually be 5 signed attorney statements describing credential discrimination by the same deputy that afternoon, and by the following morning had submitted a formal public records request for Calloway's complete disciplinary history, all filed complaints and all credential challenge records dating to his first year of employment. The contempt hearing was scheduled for 8 a.m. on the 6th morning of trial before the day's proceedings began, and by 7:45 every press seat in courtroom 6B was occupied, and 2 additional journalists were standing in the overflow area at the back. 3 defense attorneys arrived 8 minutes early, which was notable because defense attorneys in high-profile cases typically arrived at the last possible moment as a display of relaxed confidence, and the fact that they were early said something about how much the atmosphere of the room had changed over the course of the week. Brett Calloway arrived with his union attorney, Gerald Nash, and sat at the respondent's table with the precise physical stiffness of a man who is trying very hard to project confidence through the discipline of his posture, which is not the same thing as actually being confident and does not read the same way from the outside. He had put on his dress uniform because Dennis Howell had told him to, had told him it would signal professionalism, had told him that protocol was on their side. Dennis Howell was in the gallery in the 3rd row, his thinning blonde hair flat against his forehead, his hands folded in his lap with a tightness that suggested they were doing some work he had not assigned to them. Rachel Park. Elijah's co-counsel introduced the evidence in 3 pieces presented sequentially, each one building on what the piece before it had established. The first was the surveillance camera footage from the 6B access corridor on the morning of October 14th, showing the full sequence of the interaction from Calloway's initial positioning to the moment Elijah was walked toward the waiting area. The footage was clear. The body language in it was unambiguous. It showed a man presenting documents being told the documents were inadequate, making a series of further offers, and then being physically guided out of the corridor by a deputy who had not verified a single piece of the paperwork he had just rejected. The second was the cross-referenced access log analysis. 16 flagged interactions over 3 years. 13 involving Black or Latino individuals. The demographic breakdown presented as a simple and factual table without editorial commentary, which was worse in some ways than any editorial commentary could have been, because the numbers did not explain themselves or apologize for themselves or ask to be understood in context. They were simply what they were. The third piece was the audio recording from Elijah's phone. Gerald Nash objected on 2 grounds foundational basis, and the argument that the recording had been made without Calloway's knowledge. Judge Wynn overruled both objections in 16 words. The recording was authentic, time-stamped, continuously uploaded to a verified cloud server, and had been made in a public corridor by a party to the conversation. It was admitted into evidence. It would be played through the courtroom speaker system at a volume sufficient for every person present to hear every word with complete clarity. No one in the room shifted in their seat. They were very still. The recording began at the point where Calloway stepped in front of Elijah in the corridor, and it ran for 9 minutes and 17 seconds. And what happened in the courtroom during those 9 minutes and 17 seconds was something that everyone present understood they would remember for the rest of their professional lives. When Calloway's voice came through the speakers asking which defendant Elijah was related to when those specific words filled the room in that specific order, 4 people in the jury pool section shifted slightly in their seats, and a woman in the back row of the gallery who had worked for the county for 31 years pressed her lips together very tightly and did not release them. When Elijah's voice came through listing the 3 verification methods, calmly, specifically, without any trace of anger or performance, a young attorney in the press row stopped writing and simply held her pen in the air above her notebook, because what she was hearing was the voice of someone who had given this kind of information before in this kind of situation and who had learned from years of practice exactly how to give it in a way that left no room for misunderstanding, because he had understood from long experience that the truth needed to be stated clearly and completely when you were giving someone every possible opportunity to find it. When Calloway's voice came through, refusing all 3 options one after another, without pause, without reconsideration, Nash looked down at his notes with the expression of a man who is trying to find something in his notes and already knows it isn't there. When the sound of the physical contact came through the shift in the audio, Elijah's immediate and measured response telling the deputy not to touch counsel Dennis Howell in the gallery moved his hands from his lap to the armrests of his seat, and then moved them back and then looked toward the side door. When Calloway's voice said counsel doesn't show up looking like he came from a bus station, the room did not gasp. No one made a sound. The silence that followed those words was not the silence of shock. It was the silence of people who are sitting very still because they understand that they have just heard something in a federal proceeding with a court reporter present and a record being made that cannot be taken back and cannot be explained away and cannot be filed in a drawer and closed without finding. Howell stood up. He walked toward the side door. He opened it quietly and went out. 2 journalists followed him into the corridor, and he said nothing to either of them. He stood against the corridor wall with the expression of a man who has just finished calculating something and does not like the number he arrived at. The recording kept playing. When the final seconds came, Calloway instructing the second deputy in Elijah's audible presence not to let him back through without real credentials, with the specific sound of air quotes around the word Calloway himself sitting at the respondent's table in his dress uniform, was looking at the table in front of him. His hands were flat on the surface. They were not entirely steady. The recording ended. The room held the silence that follows something that has just become permanently true. Not the silence of people who are surprised. The silence of people who have heard something that confirms what they already understood, stated now in a public forum with a permanent record, and who are sitting with the weight of what it means that this is now documented and cannot be undone. Gerald Nash made his argument with the competence and care that the situation demanded and the evidence did not support. He said security work required rapid assessment under pressure. He said the interaction, while regrettable in its tone, reflected the genuine demands of maintaining security for one of the highest-profile trials this courthouse had seen in many years. He said his client had been trying to protect the integrity of the proceedings. Judge Wynn asked him to identify the specific point in the 9-minute and 17-second recording at which Deputy Calloway had made any attempt to verify Elijah Cross's credentials. Nash looked at his notes. He began to reference the appointment letter in the plastic sleeve. Judge Wynn asked him to identify the timestamp at which Calloway had read past the heading of that letter. Nash looked at his notes again. He could not identify it. He could not identify it because the moment did not exist in the recording, because it had not happened, because Calloway had read the heading and stopped and made a decision about what the heading meant and had not read another word. The room was quiet. Nash closed his folder. Judge Patricia Wynn spoke for 12 minutes, and she used the same tone she used to deliver every finding in every proceeding she had ever presided over. Factual, precise, without inflection, without the kind of rhetorical emphasis that can be clipped out of context and used to argue that a judge has allowed her feelings to drive her conclusions rather than her reasoning. She was not going to give anyone that argument. She found that Deputy Brett Calloway had removed Special Prosecutor Elijah Cross from the Harmon County Courthouse without basis in any legitimate security concern, and that Calloway had refused 3 independent verification methods offered by the prosecutor before his removal, and that the recorded evidence, the access log analysis, and the 3-year demographic pattern all indicated that the assessment driving the removal had been rooted in racial assumption rather than security necessity. She found that the removal had delayed a state prosecution, disrupted trial preparation, and created a demonstrable and documented chilling effect on a scheduled trial witness, whose testimony was central to a public integrity case of significant consequence to the citizens of Harmon County. She found that the behavior was consistent with a pattern documented across 3 years and 16 incidents. She found that Dennis Howell's public statement defending the removal issued before the surveillance footage had been reviewed, before the access log had been examined, and before any substantive account had been gathered, reflected an institutional posture that the evidence directly contradicted, and that Howell's name was now permanently attached to that posture in the court's official record. She referred the matter to the Florida State Law Enforcement Division, the Florida Bar Association, and the Florida Commission on Ethics. Then she turned to the courthouse marshal and instructed him to relieve Deputy Brett Calloway of courthouse duty effective immediately. Not suspended. Relieved. Rachel Park stood and introduced Dennis Howell's public statement, the statement he had issued at 9:34 on the morning of October 14th, in which he had said that Calloway had acted appropriately and professionally, that any individual who could not verify credentials was subject to the removal protocol, and that the courthouse stood behind the deputy's assessment. She introduced it not as an editorial comment, but as Exhibit 3, in the contempt preceding a documented statement made by the Deputy Chief of Court Services on the record in defense of a course of conduct that the court's findings had just directly and completely contradicted. She noted that Howell had made this statement before reviewing a single frame of surveillance footage, before examining the access log, and before asking Calloway for a detailed account of what had specifically been said in the corridor. She noted that his name was now permanently in the court's public record attached to the institutional response to this incident, and that the record would reflect the relationship between that response and the evidence that had subsequently come to light. Howell was not in the courtroom. He was in the corridor outside where he had gone when the recording reached the phrase about a bus station. He was standing against the wall when Rachel Park made these statements, and the 2 journalists who had followed him out of the courtroom wrote down what she said while standing 6 feet away from the man she was talking about. His prior statement remained in the court record. It would remain there permanently. Exhibit 3. 2 deputies escorted Calloway from the courtroom to the security office to collect his personal belongings, and the walk was approximately 85 feet, and it went through the main corridor and past the special access perimeter for courtroom 6B, past the exact point where he had stood with his feet planted and his eyes working and his assessment fully formed in under 3 seconds on the morning of October 14th. Three journalists walked the same corridor at a parallel distance without being asked to, and without making any attempt to conceal that they were doing so. Calloway did not look at the access perimeter as he passed it. He looked straight ahead at a fixed point somewhere in the middle distance, with the careful expression of a man who has decided that the most important thing he can do right now is look like he has decided something. His personal belongings took 5 minutes to collect. He left through the employee entrance on the building's south side. Inside courtroom 6. B. Elijah received the news through a note passed to him by Rachel Park during a brief recess. He read the note. He folded it once lengthwise and placed it in the inside pocket of his jacket next to his phone. Then he turned back to his preparation for the afternoon's cross-examination of the prosecution's financial expert, opened the worn notebook to the correct page, picked up his pen, and kept working. Brett Calloway found work as a private security guard at a commercial office complex 2 miles from the courthouse, standing at a kiosk near the parking structure entrance where his job was to check employee badges against a roster system loaded into a tablet. The system made the determination. He confirmed it. He did not assess anyone. He did not evaluate. He did not stand with his feet planted and his eyes working and form a judgment about who belonged on the other side of a door before they had opened their mouth. On some mornings, attorneys he recognized from years of courthouse work walked past his kiosk on their way to their offices. They did not slow down. They did not look at him. He had stopped expecting them to. At the sentencing hearing for Gerald Harmon, held 4 months after the jury returned its verdict, the Attorney General's office formally recognized Raymond Okafor and Carol Tran for their cooperation and their courage. Carol received a small framed certificate and held it with both hands for a moment, looking at it without speaking, looking at it the way a person looks at something they have been moving toward for a very long time and have finally arrived at. Across the room, Raymond caught Elijah's eye. One nod. Nothing more was needed. The rain came back overnight the way it comes in Florida in the fall, sudden and complete, and then gone before the workday begins. Elijah Cross arrived at the Harmon County Courthouse at 7:41 a.m. in the same navy jacket, carrying the same notebook. At the access perimeter for courtroom 6B, a new deputy, 26 years old, 9 months with the courthouse, trained on a case study he had not fully understood until he saw it, checked the morning docket on his tablet, read the name, looked up and said, "Good morning, counselor." He stepped aside and held the access point open. Elijah Cross walked through without breaking stride. If this story stayed with you, if it made you think about who gets believed and who gets turned away and what it costs when the wrong answer keeps winning, please consider subscribing to our channel. We tell stories like this one because the record matters and because the people who refuse to let it be erased deserve to be heard.